The Senate will come to order. Senator Scott. Thank you, Mr. President. Members and guests, please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, please call the roll.
Senators Aguilar, Balmer, Baumgartner, Carroll, Cook, Crowder, Donovan, Garcia, Grantham, Guzman, Heath, Hill, Hodge, Holbert, John, Johnston, Jones, Kafalis, Kerr, Lambert, Lundberg, Marble, Martinez Jimenez, Merrifield, Neville, Newell, Roberts, Scheffel, Scott, Sonnenberg, Stedman,
Absent.
Todd, Ulibarri, Woods. Mr. President,
Here.
Stedman,
With 35 present, 0 absent, 0 excused, we have a quorum. Senator Neville.
Thank you, Mr. President. I move that reading the journal for March 19th be dispensed with and the journal be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. Opposed, no. The motion is approved and the journal is adopted. Committee reports.
March 19, 2015, Committee on Education. After consideration of the Mayor's Committee recommends the following: Senate Bill 50 be postponed indefinitely. March 19, 2015, Mr. President, the Committee on Education has had her consideration has had a hearing on the following appointments and recommends the appointments be placed on the consent calendar and confirmed. Members of the State Board for Community Colleges and Occupational Education for terms expiring December 31st, 2018. James M. Johnson of Colorado Springs, Colorado, serves as a Republican from the 5th Congressional District, reappointed. Kenneth C. Wheel of Denver, Colorado, serves as a Democrat from the 1st Congressional District, reappointed. Presley F. Askew of Wheat Ridge, Colorado, serves as a Republican from the 7th Congressional District, appointed. March 19, 2015, Mr. President, the Committee on Education has had her consideration has had a hearing on the following appointments and recommends the appointments be placed on the consent calendar and confirmed. Members of the Board of Trustees of Metropolitan State University of Denver for terms expiring December 31st, 2018. Terrence D. Carroll of Denver, Colorado, serves as Democrat, reappointed. Michelle M. Lucero of Littleton, Colorado, serves as Democrat, reappointed. March 19, 2015, Mr. President, the Committee on Education has had her consideration has had a hearing on the following appointments and recommends the appointments be placed on the consent calendar and confirmed. Members of the Board of Trustees for the Colorado School for the Deaf and the Blind for terms expiring July 1st, 2018. Walter Von Felt of Monument, Colorado, a Republican, appointed. Nancy Inez Brown of Colorado Springs, Colorado, a Republican, appointed. Michelle Ann Butler of Colorado Springs, Colorado, a Republican, appointed. Christopher Allen Madison of Gypsum, Colorado, an unaffiliated, reappointed. March 18, 2015, Committee on Education. After consideration of the Mayor's Committee recommends the following: House Bill 1184 be amended as follows, and also amended before the Committee of the Whole favorable recommendation, with the recommendation be placed on the consent calendar. March 19, 2015, Committee on Finance. After consideration of the Mayor's Committee recommends the following: House Bill 1136 be referred favorably to Committee on Appropriations. March 19, 2015, Committee on Finance, after consideration of the Mayor's Committee, recommends the following. Senate Bill 207 be referred favorably to Committee on Appropriations. March 19, 2015, Committee on Finance, after consideration of the Mayor's Committee, recommends the following. House Bill 1204 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. March 19, 2015, Committee on Health and Human Services, after consideration of the Mayor's Committee, recommends the following. Senate Bill 204 be referred favorably to the Committee on Appropriations. March 19, 2015, Committee on Health and Human Services, after consideration of the Mayor's Committee, recommends the following. House Bill 1145 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. March 19, 2015, Committee on Health and Human Services, after consideration of the Mayor's Committee, recommends the following. House Bill 1111 be referred favorably to the Committee on Finance.
Message from the House.
March 19, 2015, Mr. President, the House has voted to grant the House conferees on the Second Conference Committee on Senate Bill 85 to consider matters not at issue between the two houses.
Back to Senate Services.
March 20, 2015, correctly printed, Senate Joint Resolutions 19 and 20, correctly engrossed, Senate Joint Resolutions 16 and 17, correctly re-engrossed, Senate Bills 90, 197, and 211, correctly revised, House Bill 1211, correctly re-revised, House Bills 1004 and 1067.
Senator Martinez-Humenick.
Thank you, Mr. President. I request that the Conference Committee be permission to go beyond the scope of the differences between the two houses. The Second Conference Committee needs to be able to go beyond the scope, similarly to the First Conference Committee.
Regarding
Senate Bill 85. And the reason being is that we need to change the number of people that can be involved in an LLC to be 2 or less.
the continuing saga of this bill requires the motion that the body grant permission to the conferees on the First Conference Committee of Senate Bill 85 to consider matters not at issue between the two houses. All those in favor say aye. Aye. Those opposed, no. Granted. Introduction to resolutions.
House Joint Resolution 1016 by Representatives Brown and Quorum and Senator Roberts concerning the remembrance of Ute history in Colorado and in connection therewith honoring the heritage and culture of the Southern Ute Indian Tribe and the Ute Mountain Ute Tribe.
Majority Leader Scheffel.
Thank you, Mr. President. Move the Senate lay over House Joint Resolution 1016 to March 23rd.
You've heard the motion. All those in favor say aye.
Aye.
Opposed, no. House Joint Resolution 1016 will lay over until March 23rd. Third reading of bills. Mr. Majors, please read the title of House Bill 1211.
House Bill 1211 by Representative Young and Senator Sonnenberg concerning license requirements for durable medical equipment suppliers.
Senator Sonnenberg.
Thank you, Mr. President. I move House Bill 1211 on third reading and final passage.
Is there further discussion on House Bill 1211? Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, House Bill 1211 is adopted. Co-sponsors. Senator Crowder. Please add the President. Majority Leader Scheffel.
Thank you, Mr. President. At this time, I move the Senate proceed out of order to consider two, and only two, moments of personal privilege, to make comments on a local championship team and a scholarship recipient. Ask for an aye vote.
You have heard the motion that the Senate proceed out of order. All those in favor say aye. Opposed, no. The Senate will proceed out of order. Senator Aguilar.
Thank you, Mr. President. Members, I'm honored to have with me today a recipient of a Prudential Spirit of Community Award. This is a nationwide program honoring young people for outstanding acts of volunteerism. Ms. Sydney Burker was nominated by Hamilton Middle School in Denver for her work in founding a tutoring program that's grown from a 2-week math boot camp at her formal middle school to a permanent biweekly after-school program covering all subjects at 3 schools. It all started when Sydney heard that students at her former middle school were performing unsatisfactorily in math, and she is available to tutor any of you in math that need it. She decided to conduct the 2-week boot camp, and when she achieved a breakthrough with her very first pupil, she realized the impact she could have on the education of inner-city students. Sydney worked with the school to implement a similar program for the summer and then recruited a couple of fellow high school students. And now, with close to 100 students receiving assistance from Sydney's program during the first year, the school registered an impressive increase in assessment test scores. So I think we should run the Sydney Burkhart tutoring bill next year. The program has now expanded to another middle school and to Sydney's high school, and she now has 12 tutor leaders to help lead and coordinate tutoring sessions. Sydney says, I believe in the face of profound income inequality, an effective education system can equalize the playing field for all students, regardless of their economic background. Members, please join me in congratulating Sydney Burkhart. Sydney?
Sydney, perhaps you could join us during the long bill. Colleagues, please help me welcome Senator Sam Zackham to the chamber. Senator Todd.
Thank you, Mr. President. Good morning, colleagues. Happy Friday. So today is not
Senator Todd,
Aurora
would you
Day.
like to request a moment of personal privilege?
Oh, yes. Thank you, Mr. President. May I, I'd like to request a moment of personal privilege.
Granted.
Thank you very much. Today is not Aurora Day at the Capitol. It is Cherry Creek Day at the Capitol. And we have before us a group of young men that I am so excited to present to you. Overland High School, you know it's March Madness, and so we are just thrilled to have with us today. And I have a special tribute to present to the Overland High School men's basketball team, the Overland Trailblazers, the Class 5A Colorado State champions. The members of the Colorado State Senate would like to congratulate the 2015 Overland High School men's basketball team on winning the Class 5A Colorado State Championship on March 14th, 2015. This accomplishment is a testament to the team's exceptional dedication and hard work. As student athletes, we offer our best wishes to all of their future endeavors. Members of the victorious Blazers are, and as I say your name, if you'll stand up, please, Reggie Gibson, Austin Conway, Patiette Wang, Daniel Lucas, Bruce Jackson, Duron Davis, Asad Youssef, Elijah Halliburton, Brent Halliburton, Malik Clark, Ryan Swan, King Grant Perry. The coach is Danny Fisher, the head coach. The assistant coaches, Anthony Harden, Curtis Dollison, Richard Barbian, Elliot Thompson. The manager is Shami Ahmed Naji. The principal of Overland High School and the leader of this pack is Leon Lundy. And we also have Coach Fisher's daughter, Nina, with us as well. Their overall record is 23-5. They have a national ranking of 27 out of the nation, in the nation. 27, woohoo! And of course, the Colorado ranking is #1. And so I am thrilled to have them with us here today. Overland High School is 37 years old. We've been waiting a long time. And to prove that, I brought a hat that my son had when 91 and 92, they were the Centennial League champs back then. We've been waiting a long time. You guys brought the trophy on home, and we are so proud and so very excited. There's 6 seniors in this group, and a couple of them already have scholarships to go and play ball. I've already talked with them about the Jayhawks. Some of them are with me, some of them are not. But this is March Madness, and again, this is a very exciting time for Overland High School, for the Cherry Creek School District, for Aurora, and for each and every one of these young men and their families. We congratulate you, we applaud you, we wish you the very best. God bless you all, and we are thrilled to have you here on the Senate floor today. Go Blazers!
Congratulations, you do not feel coerced to go to Kansas. The Senate will stand in a brief recess to greet our guests. The Senate will come back to order. Senator Scheffel.
Thank you, Mr. President. Request that House Bill 1046 be removed from the general order second reading of bills consent calendar and placed at the end of the general order second reading of bills calendar.
House Bill 1046 will be removed from the general order second reading of bills consent calendar and placed at the end of the general order's second reading of bills calendar, which now takes us to general orders second reading of bills consent calendar. Senator Holbert.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills, consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, consent calendar. Senator Holbert will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, would you please read the title of all the bills on the general orders, second reading of bills, consent calendar?
House Bill 1223 by Representative Williams and Senators Balmer and John concerning the extension of current standards regarding home service contracts to new homes. House Bill 1213 by Representatives Tate and Tyler and Senators Martinez, Humanic, and Neville concerning clarifications in connection with the responsibilities of the Office of Information Technology. Senate Bill 208 by Senator Cafalas and Representative Brown concerning capital-related expenditures in connection therewith granting the controller authority to allow expenditures for capital construction budget appropriations if non-monetary adjustments are needed when the legislature is not in session, adding a capital development committee approved waiver for the arts and public places requirement, and clarifying the types of capital construction projects to which the arts and public places requirement applies.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Move the committee adopt the remaining bills on the general order second reading of bills consent calendar, which includes House Bill 1023, House Bill 1213, and Senate Bill 208 and its associated Finance Committee report, and ask for an aye vote.
Is there any discussion on any of the committee reports?
Mr. Chairman.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Just want to clarify. Bills on the consent calendar, House Bill 1223, House Bill 1213, Senate Bill 208, and its associated Finance Committee report. Ask for an aye vote.
Thank you, Mr. Majority Leader. Now the question before us, is there any discussion on any of the committee reports of any of the bills listed on the consent calendar? Seeing none, the question before us is the adoption of committee reports on all the bills on the consent calendar. All in favor say aye. Aye. Those opposed, no. The ayes have it, and the committee reports are adopted. Is there any discussion on any of the bills on the consent calendar? Seeing none, the question before us is the adoption of all of the bills on the consent calendar. Those in favor say aye. Those opposed, no. The ayes have it, and the bills are adopted. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
The motion before us is to rise and report. All in favor say aye. Those opposed, no. The ayes have it, and the committee will rise and report.
Thank you. The Senate will come back to order. Senator Holbert.
Thank you, Mr. President. Your committee has met, had a number of bills under consideration. Mr. Majors, would you please read the report?
March 20th, 2015, Mr. President, your committee holding two reports that in consideration of the following task bills being second reading thereof makes following recommendations thereon. Senate Bill 208 is amended passed on second reading in order to gross place on counter for third reading and final passage. House Bills 1223 and 1213 passed on second reading in order to revise place on the counter for third reading and final passage.
Senator Holbert.
Thank you, Mr. President. I move adoption of the report.
Is there further discussion on the report of the Committee of the Whole? Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the Committee of the Whole report is adopted. Senate Bill 208, as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1223 and House Bill 1213 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Holbert.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for consideration of second reading of bills. General order, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills. Senator Holbert will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, would you please read the title to Senate Bill 135?
Senate Bill 135 by Senators Martinez, Humenick, and John concerning modifications to statutory provisions governing urban redevelopment affecting public bodies in connection with urban renewal projects.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 135 to March 23.
The motion before us is to lay over Senate Bill 135. All in favor say aye. Those opposed, no. The ayes have it. Senate Bill 135 will lay over to March 23rd. Mr. Majors, would you please read the title to Senate Bill 69?
Senate Bill 69 by Senator Woods and Representative Priola concerning the repeal of the Job Protection and Civil Rights Enforcement Act of 2013.
Senator Woods.
Thank you, Mr. Chair. I move Senate Bill 69 and the Appropriations Committee report.
To the committee report, Senator Woods.
Thank you, Mr. Chair. The appropriation was added to the bill with the committee report.
Very good. Is there further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. All in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the committee report is adopted. Senator Woods, to the bill.
Thank you, Mr. Chair. Senate Bill 69 is a repeal of House Bill 1136 from 2013. And as I begin today, I want to tell you some things about me and about my business, because during the hearing on this bill and since this bill was heard in committee, I've been accused of being a lot of things. But what is true about me is that I am not a person who discriminates. In my business, we hire women, we promote women. Currently, 10 of our 12 employees are women. We've had over the years members of the LGBT community in our employee. We have in the past and currently employed minorities. And in my family, I have relatives who are in the LGBT community. And on my journey to this office, I worked closely with at least one person, also from that community. Now, I'm not up here to tell you that I understand what it's like to be a member of the LGBT community, nor can I tell you I've walked in the shoes of a minority, but I can tell you I am not a racist, I'm not a homophobe, and I do not discriminate. Let's be clear from the very beginning of the discussion today, this bill is not about discrimination. Every member of the Business Committee, as well as every witness who came in to testify about this bill, heard myself and other witnesses all agree that employers who discriminate should be taken to task. Senate Bill 69 is about protecting small businesses. As my colleague from Boulder said in the hearing, Colorado is a small business state. We heard this over and over from this very podium earlier this week, with a great number of our employers employing less than 15 people. That's the definition that the federal government uses to define a small business, less than 15 employees. And when the federal government established the Civil Rights Act, it very wisely made different guidelines and rules for small businesses as opposed to large. Why? Well, not because discrimination can't happen in any workplace. We all know it can. But the federal government knew that small businesses would be put out of business if they had to face the penalties and the fines and the punitive damages that large businesses have to face. House Bill 1136 from 2 years ago came into effect on January 1 of this year. And in the meantime, the Colorado Civil Rights Division was to be out educating employers of the risks that they would face once the law came into effect. While the CCRD did schedule some meetings around the state, Most small businesses today still don't know the risks that we face if we don't pass Senate Bill 69. So let's talk about those risks. Under House Bill 1136, small businesses who are charged with discrimination, regardless of whether the claim has merit or not, are going to have to hire an attorney and defend themselves. The CCRD 2014 annual report reveals that 95% of the claims of discrimination are found to be without merit. That means that a disgruntled employee sues their boss just to get even or just to vent their anger, and in 95% of the cases, small businesses pay out attorney's fees when they have done nothing wrong and to prove they have done nothing wrong. If a business has discriminated, the CCRD will determine the case to have merit and that employee should be made whole. Before the 2013 law was passed, the employee could get front pay and back pay and reinstatement. In fact, until December 31 of this year, that was what employees could get. And employees always have a right, as any citizen does, to sue their employer in state court. But under 1136, which was passed in 2013, small businesses now face having to pay punitive damages, compensatory damages, and the claimant's attorney's fees. This is in addition to paying their own attorney's fees. Witnesses testified at the hearing that to go to court will cost an employer $100,000 to $150,000. Now, I am a small business owner. We have just under 15 employees. I can tell you I do not have an extra $150,000 in the bank. I don't even have an extra $20,000, which is what may be required to settle a claim, whether it has merit or not, to avoid going to court. And this law applies to small ranches and farms, to small nonprofit agencies, to anybody who has employees. Small businesses like mine know that our employees are our bread and butter. We treat them right because we need to keep them as employees. And we don't have extra money sitting around because it goes back into employee benefits like health insurance and 401k plans, all of which are costing us a lot more today than they did just a decade ago. House Bill 1136 put a target on the back of every small business in this state. It launched Colorado into being one of the most punitive states in the country by adding punitive, compensatory, and legal fees to the remedies, and it caused Colorado to be the most punitive state in the Rocky Mountain region. Why would small businesses want to open up shop in Colorado when every hiring decision, every layoff, every firing, they're opening themselves up to a lawsuit? And the state of Colorado is looking to punish them for those decisions. House Bill 1136 will put small businesses out of business, and it will cost Colorado citizens their jobs and the benefits attached to those jobs. Senate Bill 69 is being supported by both NFIB and Casey because what 1136 does to large business is almost as bad as what it does to small. Under the prior law, employees with complaints could go to the Colorado Civil Rights Division if they worked for a small business. If they worked for a large business, they filed with the EEOC, and if a lawsuit ensued, it was handled in federal court. Under 1136, employment lawyers can now forum shop between state and federal court, and employers testified that to be sued in state court is much more costly than going to federal court. It usually means a trial to a jury, not to a judge, so there's a possibility for that runaway jury verdict. There isn't the case law at the state level court that there is in federal court, and the federal courts are generally better at adjudicating these types of cases because they have the experience and the case law. House Bill 1136 was bad for small business. It's bad for big business, and it's bad for jobs. It seems like it's bad all around, except, friends, there is one group who stands to benefit from 1136, and that's the trial lawyers who take these kinds of cases, even if there isn't any discrimination, who venue shop to find the court that will result in the biggest paycheck and who demand that a small business settle to avoid the high cost of going to trial. To vote against Senate Bill 69 is a vote for that group here in Colorado. This is a bipartisan issue. Every one of us here in this body has constituents who own small businesses. Many of those business owners are women and minorities. And to vote against 69 is to tell those constituents that their business doesn't matter to you, their senator. If they're discriminating, there are laws in place to deal with that, and they should be dealt with. But to put every small business and large at risk so that the trial lawyers can make more money, that's just wrong, and that is not what you and I were sent here to do. Are there employment issues that need to be dealt with? Yes, but let's work together to create a solution that doesn't destroy small business. So I urge an aye vote on Senate Bill 69. Thank you.
Senator Guzman.
Thank you, Mr. Chair. I want to first start off by saying how offended I am. How offended I am that a colleague in this chamber, this Senate chamber, which is known to be one of protocol, one of respect, to say that, to insinuate that I am opposed to this bill only because I am here to support the trial lawyers. That is offensive, it's shallow, and it's unacceptable, and I think it's un-American. I am here to talk about this bill not because I favor the trial lawyers. I'm here to talk about this bill, and I am opposed to this bill because I want to go back to the March on Washington, which was called the March on Washington for Jobs and Freedom, August 28, 1963. And they had there a list of 10 issues that they were demanding. And the 10th one was, we demand a federal Fair Employment Practice Act, barring discrimination by federal, state, and municipal governments and by employers, contractors, employment agencies, and trade unions. This bill, this law has been important to me certainly since 1963 and continues to be important to me. I, too, owned a small business. I feel that it's part of my responsibility to protect civil rights. It's part of being a good business owner. Why should we embrace one standard on discrimination for one size business and allow it with others? Allowing discrimination to persist in the workplace is immensely harmful to business, especially to neighborhoods. Look at where your small business is, those businesses that have 15 or less employees. Look at where they are. They are located in neighborhoods. Take my neighborhood, for instance, that whole area of Northwest Denver. I talked to my favorite local liquor store owner. I know that one senator knows I go there a lot. He has 14 employees. I asked him what he thought. I asked him what he thought about needing to be responsible as a business that was not discriminatory. He said, "Are you joking? Are you kidding me? I don't need to be set aside. I don't need to be protected. I run my business, and if somebody has an issue with me, we'll talk about it, or I'll do whatever I need to do." I talked to 5 local coffee shops in my district, all of them less than 15 employees. All of them would be opposed to this bill. I talked to my auto mechanic store. His store is on Lawrence Street. I can tell you where it is. I don't know which small businesses this sponsor or the people who are supporting this bill are talking to or about. But when I talk about a small business of 15 or less, that is truly a small business. They are known, if they're successful, they're known in their neighborhood, they treat their people well, and they don't have to worry as much about what's going to happen in one of these situations. Why is it? Why would we want to embrace one standard on discrimination? Why would we want to pick and choose who needs to follow the law and who doesn't need to follow the law, especially when it has to do with acts of discrimination? I oppose this bill, and I ask you to do the same.
Senator Ulibarri.
Thank you, Mr. Chair. And thank you, colleagues. I rise in opposition to Senate Bill 69 as well. When we talk specifically about this bill, we hear about acts of discrimination. And that harkens back on some older time, some other time when people had white picket fences and there was a civil rights movement that was happening. And somehow we imagine it as another time, far distant and removed from us today. And I want to say that's not the case. That's actually not true. But let's actually talk about what discrimination looks like in people's lives. Imagine going to work as a person of African descent and being told that you are the tribe's assistant and being called a lazy, stupid African. Imagine being given only one shift option at work, based not on the content of your character or your ability, your brains or your passion for the work, but just on the color of your skin. Imagine being forced out of workplace opportunities, the ability to receive a promotion, not because you're incapable or unable, but because of who you are, the color of your skin. Sounds shocking, sounds distant, sounds far removed, but what I just described to you is a case that was recently settled in my backyard in Commerce City, where 7 employees, all of African descent, were given a separate shift based on the color of their skin. They were called lazy, stupid Africans. They were told that they were the tribe's assistant, and they existed in a hostile work environment. Why did they do that in 2007? Why did they continue to work there in 2008? Why did they continue to do that in 2009? Anyone remember what was happening at that time? The Great Recession, where folks were looking for work and ability to survive and provide for their families and were willing to endure horrific treatment at the hands of their employers. They couldn't have just gone some other place and found a job because guess what? There were thousands of Coloradans looking for work at the same time, to walk away from a paycheck even in inhospitable climate. In this millennia, not in some bygone era, in this millennia, in my backyard, in Commerce City, in a trucking warehouse. Can you imagine it? Because it's not fiction, it's reality. One of the men, Ernie Duke, who was discriminated against, said, "I thought I was back in the South with the same old racist attitudes." A man who was raised in Missouri. Racial discrimination is not our long-forgotten past. It is our current present for folks who work today. Thankfully, these men, because there were more than 15 employees, had the ability to take their case to court. But just imagine if there had been 14 employees. We would have said, "Oh, well, I'm sorry, there's a separate and unequal system of treating your discrimination claim. We will have a second tier for you. No matter how horrific you were treated on the workplace, no matter how you were discriminated against, no matter that less experienced people with less ability to do your job were given promotions over you, solely based on the color of your skin." Well, in 2013, we passed a law to equalize the system, to say that discrimination is wrong no matter how many employees you have, and there should be an ability to rectify said discrimination. Pretty simple, pretty straightforward. And Senate Bill 69 would erode that progress to say that there should be one standard for dealing with discrimination. That when these current and present acts of discrimination happen in our communities, when these current and present acts happen to our neighbors and our friends and our colleagues, our family members, there should be an ability for justice. Last year, I sat in the committee hearing with a very similar bill to eliminate House Bill 13-1136. And I heard the story of a young woman named Rachel who worked at a sandwich shop, like most teenagers do, finding a place early in food service to make some money. And not only was she discriminated against based on her gender, she was harassed over and over. A male supervisor who kept trying to make advances at her, and she had no legal recourse because she was in a small business. Think about your first job. Think about your ability just to pick up and move to another job after being treated like a piece of meat in a sandwich shop. And you're 17 and you don't know where to turn. I can't imagine that we're standing here in 2015 when we know, when headlines show, when our neighbors say, when our friends and family members, our daughters say, discrimination exists, and we're going to say, let's get rid of the ability to address these claims? Let's get rid of the ability for justice? Seems like the wrong direction to take for Colorado.
Senator Stedman.
Thank you, Mr. Chairman. And colleagues, I also rise in opposition to Senate Bill 79. And I hadn't planned to speak this morning to this bill, but the sponsor's opening comments intrigued me, and I wanted to respond, because the sponsor has told us that she herself does not discriminate and that she harbors no ill will or malice towards others based upon any of their immutable characteristics. And I believe her. But the issue before us, colleagues, is not the content of her character. It is the content of her bill. This bill would remove remedies for persons who experience discrimination, particularly in small businesses where federal law leaves a gap, and state law has been the vehicle for filling that gap. We're talking about small businesses that employ fewer than 15 people. And I think that issue's been made very clear, that that's really where this bill strikes at the very remedies that provide justice to people who have experienced discrimination in small business settings. To say that every person's civil rights are respected and protected in the state of Colorado is a wonderful thing. But to know that when those rights have been violated, there are meaningful remedies to provide recourse is quite another. Because as we all know, rights without remedies really aren't worth much at all. And that's the step backwards that Senate Bill 69 is inviting us to take, to remove remedies for those who have experienced injustice. It is the content of this bill that I object to. This bill will provide remedies in situations where federal law leaves a gaping hole, and it will provide remedies in situations where our current Colorado law prior to 2013 was most inadequate. And an example of the inadequacy of the prior law are cases of, again, small employers with fewer than 15 employees where someone has, say, been sexually harassed in the workplace, a hostile work environment, quid pro quo sexual harassment. Make it as blatant as you want. If the victim of that harassing discrimination does not quit her job because she has to have that paycheck, because she has a family to support and bills to pay, and endures the sexual harassment, the prior law offers little by way of remedy. Now, she may choose to quit because she finds the environment so hostile and unacceptable that she can't bear it, and she may then choose to file civil rights charges where she must allege constructive discharge, that it really wasn't a voluntary separation from employment. She was forced out because of the discriminatory, hostile work environment. That's a difficult case to prove, but at least in that case, if you can get to that point, you're able to access the one remedy that prior Colorado law, prior to 2013, made available, which was back pay. You could be reinstated with back pay. That was the only remedy, meaningful remedy, that was really available. That law was changed in 2013 so that that person didn't have to quit her job and allege constructive discharge. She could just file a claim of harassment and hostile work environment and seek compensatory damages for the harassment that she has endured. We are removing that protection from people who experience sexual harassment in the workplace when there is fewer than 15 employees. That is a step backwards. There are other gaps that exist in the federal law still today. There are other gaps that existed in Colorado law prior to 2013 that this bill would reopen, and I am opposed to the bill for those reasons as well. But I wanted to speak specifically to the notion that because the sponsor does not discriminate, this bill's okay. I believe her. I believe she doesn't treat people unfairly in the workplace. But there are people that experience sexual harassment and workplace discrimination in small businesses all across the state. And if we take this step backwards, they will have no access to meaningful remedies to what they've experienced, and that would be a shame. And for that reason, I'm voting no.
Senator Merrifield.
Thank you, Mr. Chair. I have been a small business owner. I owned an espresso bar in Manitou Springs and a small theater production company as well. And I'm really puzzled as to why this is difficult to address. If this law is onerous, then just don't discriminate. Then you don't have to worry about it. But I wanted to respond specifically to just one tiny thing, because my colleagues who've gone before me have more eloquently expressed their concerns and frustrations with this bill. But the sponsor of the bill said that this has been bad for Colorado, it's bad for job growth, and bad for small business. And I just Googled really quickly, job growth Colorado, and so to see if that's really the case. And so real quickly, I got a page here, Leeds study, Colorado among top 10 states for job growth. Top cities and states for job growth include Colorado and Denver. Denver ranked top in job growth, as does the state of Colorado. This is a business journal. This is the Leeds study. This is Forbes, Colorado job growth to continue to grow. Channel 9 News, Colorado and Denver both ranked in the top 10 for job growth. So I just wanted to respond to that one issue. I don't find that this has been detrimental to job growth in Colorado, so I wanted to respond to that one issue. Thank you.
Senator Lundberg. Senator Lundberg.
Thank you, Mr. Chair. I come down to support this bill. A couple of things come to mind. One, in answer to the question of what effect has this had on job growth thus far. If you look at the statistics, you're talking about the job growth before this bill, not the bill we're discussing today, but the bill that it would be repealing, the law that it would be repealing, went into effect on January 1st, 2015. What statistics do we have following then? So I find the argument to be rather hollow that it has had no effect thus far. Yeah, because it has only been in effect for a few months, and there are no statistics available for that. But I come down to just speak of this one point, and that's unintended consequences. Many of the arguments we've heard against this legislation, this Senate Bill 69 that we're looking at today, make sense if it were that simple. But it's not. And the cold, hard reality is that the terms that the current law that did go into effect on January 1st of this year
will have such a punitive effect on small businesses, not all at once, because most of them don't even know it exists, but wait until they get that notice and discover that they are out of business because they cannot afford to defend whether or not there's any factual basis. That's why federal law did draw the line and say, no, for the smallest of businesses, this does not make sense. It's the unintended consequence that is so sure to affect all of business that all of business has risen up and said, you know, the organizations that represent businesses have uniformly said this is a bad idea for the people of Colorado. We heard some arguments about how tough it is to get that first job and how vulnerable you are as an employee. Well, try it this way. What if that job isn't there at all because that employer got caught by a lawsuit, and the sponsor has told us that 95% of those lawsuits are not with sufficient merit, but it doesn't matter because that business is out of business. It's the rare small business that can afford a six-figure legal bill. It's the unintended consequences, and we have done this before. Look at the front page of today's paper, and I'll talk to you about unintended consequences. Let's not do that again. Pass Senate Bill 69, because this bill addresses the issue in a reasonable circumstance. Thank you, Mr. Chair.
Senator Heath.
Thank you, Mr. Chair. Every once in a while, I think we feel compelled to get up to this mic, and this one really compels me to do it. The notion that this bill is not about discrimination. I'm not sure how you can describe it any other way. Businesses of any size and any organization, whether it's business or any other kind of organization, should be held to the same standard. What is magic about the number 15? What is possibly magic about the number 15? When you start a business, things go up and down, as certainly mine did in manufacturing. Because one day you have an order and the next day you don't. And you have to add and subtract from your workforce, even though you just as soon not. You'd love to think everything is just up. So one day I have 15 and the next day I have 14. Are you going to decide when I discriminated and make your defense based on whether I happen to have 15 that day or 14? This bill that we passed outlawed discrimination based on disability, race, creed, color, sex, sexual orientation, religion, age, national origin, or ancestry. This bill eliminates those protections. Oh, whoops, I made a mistake. It doesn't eliminate all of those protections. It doesn't eliminate the one based on age. I'm probably the luckiest person in this room because you can't discriminate against me because I'm over 70. I happen to be 77. Why, if this is so onerous on business, why is it okay to discriminate against everybody else but me? This is the most unbelievable part of this bill. It is obviously going to destroy business in this country, in this state, but not if you discriminate against me. I think this is the first time in my life I felt privileged. A 77-year-old white guy. 69-year-old black or Hispanic person, not quite so lucky. Not quite so lucky. This makes no sense at all. This is a numbers game. 15 doesn't mean anything. What could possibly be magic about 15? We're talking about here the rights, privileges of every person in this country, not if they happen to work in an organization with more or less than 15. And this notion that this is destroying business, I'm sorry, this bill we passed in 2013, everybody that would open a business in this state understands where we are. We are the envy of this country. You're going to hear a lot of bills about job training, workforce development. Why? Because we have jobs that are going unfilled because we have such an aggressive and wonderful and productive economy. Nobody's not going to come here because they have more or less than 15 employees. If anybody believes that, let's talk, let's have a conversation. Talk to any employer. When they get to 14, do they say, oh, we're going to stop? Because if I have 15, I'm going to be subject to an anti-discrimination bill? Come on. That's not even in the cards. This bill makes no sense at all. This bill is about preserving the rights and dignity of every person in this country, regardless of where they work, regardless of the size of the company. This makes no sense at all. We are a state that by any measurement is the most welcome to business. All we got to do is look at where we are. I look back at the 7 years I've been here and where we were 7 years ago and where we are today. It's because of, I think, a lot of the things that we've done here, and obviously what we've been here to do is make it and encourage business to come here, and we've done that. The proof is in the pudding. We should not, by any measurement, eliminate this bill. It makes no sense. 15 is not a magic number. 70 is not a magic number. I would urge you to vote no on this bill.
Senator Jean.
Thank you, Mr. Chair. And I will just say that to answer my good friend and colleague from Boulder, you're absolutely right. It is absolutely, absolutely wrong on every level to discriminate. Every level. And I have no disagreement with that. And people have said to me, oh, so you just think it's okay to discriminate? Because I did oppose House Bill 1136, and I do support this, and I'm going to tell you why, and I'm here to defend my vote. I don't like speaking against so many of my good friends, and I'm not speaking against you. I'm agreeing with you on the discrimination piece. It is absolutely not okay anywhere, anytime, for anyone. I have been there to support all of the strong anti-discrimination laws. You know, in 2007, I was a strong advocate for the legislation, the Expanded Employment Non-Discrimination Act that Governor Ritter signed. And I say that anybody does discriminate anywhere, anyhow, to anyone, shame on you. To me, the bill in 2013 and this before me today, my concerns are about the venue and the remedies. You know, the discrimination laws we had in place, we did have. Some have said, well, we had nothing. No, that's not true. We had the Colorado Civil Rights Division where these discrimination filings could go. I asked
in 2013 when the lobbyists came to my office over and over and over again, several times. In fact, also the year before, because they were going to run it then. I need to know what we're trying to fix. I get the discrimination thing. I am with you on that. Not okay. But I also need to know, is it a serious problem? And over I asked for the cases. Please bring me the data. Please bring me the cases. And finally, the lobbyist said, okay, Senator John, I get it and I agree. It's rare. And I said, then what are we doing? These remedies are so strict. That is what's going to cause the problem, going from nothing to, oh my God. So the things that I have heard, that they were previously exempt from the federal and state anti-discrimination law. No, we had the CCRD. 42 other states have enacted laws that provide these protections to small business as well, in some way. But let me give you the actual statistics that I've pulled up. The majority of all the states, 29 currently, do not permit punitive damages against employers of any size. That's what 1136 did. Almost all of Colorado's neighboring states, and even several large states like New York and Illinois, do not permit punitive damages in employment claims. 1136 did that. Only 7 states permit compensatory, which is the pain and suffering, and punitive damages against all employers. That's what 1136 did. Of those, only 5 states also permit unlimited plaintiff's attorney's fees. That's what 1136 did. The vast majority of these states, 36, exclude the smallest employers from some or all of their employment penalties, as did the federal law. And 1136, of course, changed that. And it has no such protections. The average business size excluded by other states is about 9 and fewer employees. House Bill 1136 permitted a prevailing plaintiff to recover the unlimited attorney's fees. However, unfairly denied the same right to an employer who is unjustly sued. Only 13 other states expressly do the same. So the big question we asked was, okay, I get it, and I am with you all. Discrimination of any kind, anywhere, anyhow, to anyone is not okay. So how are you going to tell the little businesses that this has now gone into place? Because that's my concern. How do you know? People say, well, just don't do it. Oh, please. We all know that the majority of these, and I've been told, I'm right, the majority of these were frivolous claims. How are they going to know? Well, I'm telling you, they put together an incredible program. And if you happen to be a small business that has time to go to the chamber meeting, or first of all, belong to a chamber because they're kind of expensive, or if you happen to belong to NFIB, maybe you would have heard about it, but all the little businesses I've talked to know nothing about this law. They agree with me 200% that discrimination of any kind, anywhere, anyhow, to anyone is absolutely unacceptable. But oh my God, they don't know about this law. So they need to be protected. Because most of them think, and you can't make this stuff up, go ask them, they think they're covered under their insurances. Well, they are if they happen to purchase the rider very specific to discrimination law, the EPL. If they happen to have purchased that, which you don't know what you don't know, so if you think you're already covered, how would you know to ask? I mean, you don't know what you don't know. So 1136 allowed, well, it actually put the limit on the damages as follows. As far as the compensatory and punitive damages, of which, remember, most states don't offer both. 1 to 4 employees, 10,000. Well, that'll close a few small businesses of 1 to 4. 5 to 4, 25,000. 15 to 100, 50,000. 101 employees to 200, 100,000. 201 to 500 employees, 200,000. 500 employees and more, 300,000. So in their outreach plan, and you can get a copy too, I made sure to get it from the division. They only know about it if they happen to belong to one of those groups. Now, the insurance companies are really happy. I have to tell you, my lady, she was happy too. Because this is going to, obviously, once we make sure that the small businesses know about it, make sure that they know that they need to get covered. And of course, remember that the policy is not cheap. I think for employees around 10 to 12, it's about $1,500 a year. But I think it's now our duty, because we said we would. I think it's our duty to make sure that these little businesses know. So as you're out speaking with them, please at least tell them that the law is in effect, went in January 2015, so that they can get covered. You know, even a frivolous claim, and this is what the attorneys told me, according to what they said, the costs can still be a good $10,000 from these little businesses, even if they settle. Or most of them told me, because I went and spoke with attorneys that actually do employment law. Yeah, I want to hear from the horse's mouth. He said, first of all, are you serious? We're not going to settle. We're going to go to court. Because the settlement will always go up. You'll always get more. I always tell my client, no, go for more. So make sure you go into the court process. You may end up settling, but go into the process first. You'll get more. And this is from them. I didn't make this up. It is easily $100,000 or more, they told me. Easily $100,000 or more. I don't know many small businesses that can take that hit. So please, as you're out there, make sure they know that they have to buy an additional insurance policy. The other part, the part that the venue, federal law is where the employment laws have gone. They have the expertise, and they are the ones that usually handle the cases, and we're going to put them into state court now. Well, we all know about our state court system. They're about 2 years backlogged all the time. We can run up the cost a little bit more. So when are the small businesses going to know about this? Yep, after the lawsuit is filed. So we want the small businesses to raise their wages. We want them to give more benefits. We want them to hire more people. But at the same time, put in places barriers like this with a remedy that's going to cause hindrance. I mean, you can only pay for so much as a small business. And like I said, discrimination of any kind, anywhere, to anyone, anyhow, is absolutely wrong. But I think the person that said it the best is actually my oldest son, who all of you know helps me run my business while I'm down here. And we don't talk about politics because he's really not into the whole thing. But I was on the phone with my insurance agent talking about this and being kind of frustrated when I got the price and all of that. And he said, what in the world is going on? And I told him about the law that we had passed. And this is what he said. Couldn't have said it better. This is what I don't understand. Over and over, I hear how much the corporate world is taking over. But over and over, I see them making it harder and harder for small businesses, just for the time I've been here with you for 10 years. What we're headed for is a complete takeover by the big corporate world. They aren't going to have to worry about it because there aren't going to be any small businesses left. All that we'll have are those big box stores and the big corporations, and we'll just all go to work for them. the ones that we say we hate. I just don't get it. So it is not about allowing discrimination for me. Ever. It is about the venue that we took it through, and it is about the remedies that I think that we could have had some real negotiations on. Thank you for your attention and time.
Senator Ulibarri.
Thank you, Mr. Chair. Colleagues, I wanted to raise a few other points that I neglected in my first comments, and I appreciate the very respectful debate we're having about this bill. And I want to speak really about the impacts, and the previous speaker mentioned data, and that we need to actually understand that the decisions we're making are rooted in data. So let's talk about that. In 44 other states that have anti-discrimination laws that apply to small businesses, I challenge anyone in this chamber to give me the name of one business that has shut its doors because of an anti-discrimination lawsuit. Just one. Just one in one of those 44 states. One here in Colorado. I know it's been in effect for 3 months now. Just one. Love to hear about it. Haven't heard about it anywhere, but would love to understand it. And the other part I want to talk about, there were two other comments made both by the bill sponsor and the previous speaker about venue shopping, and that instead of going to federal court, you could go to state court, and that somehow is a negative thing. And I think about the 19-year-old young woman discriminated against southwestern Colorado, who maybe is working a minimum wage job or just above minimum wage job, who's trying to figure out, how do I bring my case in federal court, which is only located in Denver, to allow it in state court? Seems like it's a fair thing that plaintiffs who live far from Denver, if this bill passes, if Senate Bill 69 passes, could be forced to actually have their issues litigated in federal district court only in Denver, not in state court. How would you make that remedy real? How would you resolve that case if you are that single parent experiencing daily harassment by your overbearing boss who is making sexual advances? How do you find the time to travel to a federal district court in Denver to make that claim real? I don't understand it, because I don't think that's how most folks would work. They would unfortunately be put in a hostile work situation, be forced to stay there, because there is no local remedy. So the passage of Senate Bill 69 would remove the ability to take cases into state court, that's true, and it would have significant harm to those who don't live in the metro area. Seems like an attack on those who live in rural areas. The second part that I wanted to talk about is that there are civil rights processes that were enumerated, and I agree with the previous speaker that there were civil rights protections enumerated that you could take your claim to the Colorado Civil Rights Division, and that you could present your case there. That was an administrative option that you had. And again, I want you to put yourself in the position of being a young worker, say a 20-year-old who for the first time is working in a hamburger shop or working in a small local retailer, experiencing discrimination, harassment, maybe racial epithets, maybe gay slurs, whatever it is. And now you have to take your case all by your lonesome and prove it in front of the CCRD. Prove it enough that they'll say, okay, we'll move forward, we'll put investigators on this, but you're 20. You don't have many resources, and you're trying to figure out how to navigate this world, and what you're most worried about is, do I have enough money for the rent? And Lord knows the rent's pretty high. And you're saying, do I have enough time to make my case? Do I have all the resources I need? Do I even know what questions to ask to ensure that I'm being protected and that I can move my case forward? It's a pretty big burden on that 20-year-old college student who's just trying to make her way through the world. This changed that dynamic to say, actually, it should be better than that. that we should have remedies that are real, that you can actually, someone on your side to help with the investigation, someone who can actually make the case and make the consequence real. My daughter is 4, and as a parent, these are the things I worry about now. What will happen to her when she enters the workforce? How will she be treated on the job? And will there be an ability for her ultimately to be treated based on the content of her character, not on her gender? Colleagues, again, I ask for a no vote on Senate Bill 69.
Senator Cook.
Thank you, Mr. Chair. I too wasn't going to come down and speak until I heard some of the comments, and I rise in support of this bill. We all can mention stories, and I'm going to bring up one of mine. I led an organization of 350 people, and so obviously I wouldn't have fallen into this group. It wasn't a business, so I wouldn't fall into this law. But I do have a story. I was being sued for sexual discrimination because I did not promote a person. This person came in number 10. It didn't matter that she came in number 10 out of 10 that tested. It didn't matter that I promoted the person that came in number 1, which was a female. I still got sued for sex discrimination. And then when we pointed that out to her and her attorneys, that she came in 10 out of 10 and that we promoted a female who came in number 1, a couple months later, they amended their complaint to say it was for retaliation. We finally got summary judgment. And for those that don't know what summary judgment means, it means we won. She was going to settle for $5,000 2 weeks before the judge made his decision. But I said, no, we're going to go all the way. We're going to, let's take this to court. So 2 weeks later, I got summary judgment, meaning it was frivolous. The case had no bearing. But we spent hundreds of thousands. A fine senator from Lakewood who was talking about most cases are $100,000. We spent hundreds of thousands of dollars on that case, defending myself and the sheriff's office, and we finally won. We didn't get attorney fees. We weren't able to recoup those costs. We did get court costs of about $6,000, and I went after her for that and garnished her wages when she was working at another place. But we couldn't recover the hundreds of thousands of dollars on attorney fees that we spent. I can't think of any small business that can afford hundreds of thousands of dollars and spend 4 to 5 years in court, in state court, what this bill allows. So I would ask for a yes vote on this bill to protect our small businesses.
Is there further discussion? Senator Neville.
Thank you, Mr. Chair. I want to focus on one thing. Actually, I'll go a little farther. You know, some people have accused this of being the Trial Lawyer Job Protection Act. Actually, I'll call it something else. Being in the insurance business, my wife and I operate a small insurance agency. I'll call it the Insurance Agent Enrichment Act, because that's what it does. We sell more insurance. Because if you're a small business person and you don't take out EPL insurance to protect you from one of these lawsuits, it's like going without health insurance for an individual. It's the same thing. One of these lawsuits, only one of these lawsuits, has the opportunity to cost you a minimum of approximately $75,000. And that's not coming from me, that's coming from those that are lawyers and attorneys who are involved in protecting and also litigating these cases. Now, I ask you, in my case, $75,000 is much larger than my average annual income from our small business after we pay for all of our other expenses. So what happens in that case? Well, first of all, yeah, we're going to get the insurance. Or, in the case of my situation, my wife and I operate the insurance, the insurance agency. We're probably not going to bring on employees. Because if we do, we know that in addition to the cost of that new employee, there's a minimum of cost of anywhere from $500 to $1,000. And here's the thing. I've heard my colleagues here say, if you don't discriminate, it's not a problem. That's not true. That's not true. I've told you why you have to have this insurance if you're a small business person. If you don't, you really put your whole operation in jeopardy just from one case. Let's get past that point. So $500 to $1,000. What does that cause to the business? Well, that's an actual expense. So when we talk about businesses making decisions to come to Colorado or not, I'm sure we're going to have all these tremendous job creation bills that are going to be coming up. And frankly, what I heard from most of the small business people is simply leave me the heck alone and let me operate my business. I don't want to be selling this extra added insurance. Let's make sure that this is not an either or. Prior to this bill, there were remedies. Equitable relief, back pay, reinstatement, hiring. Frankly, if somebody's working with a small company, yes, companies should not discriminate. And I'm not here to even talk about that because I find it insulting. This is basically like the question of, when did you stop beating your wife? But I don't beat my wife. Well, when did you stop? This has got to have this protection. But let's be clear. When we talk about this not being an added burden on small business, frankly, I've explained to you why that is an added burden. I've explained to you also, other than trial lawyers, who this enriches. I don't want that kind of money. I want businesses to be able to thrive and achieve their goals and their dreams on their own. And I want them to hire more people. So I encourage and I vote on Senate Bill 69.
Senator Newell.
Thank you, Mr. Chair. Well, members, the first time this bill came around I voted against it in spite of pressure from my own caucus. But what I realized in looking at it was that there was no preparation for the small businesses. There was no training, there was no education and awareness that this was going to be happening. And so during that summer, after that bill had died, I brought together a network of my HR colleagues, and across the state, through some of the chambers of commerces and through the Mountain States Employers Council, we conducted some trainings on anti-discrimination, basically protecting yourself as a small employer from discrimination lawsuits. And after that, then this bill was going to come forward, and the sponsors of that bill came to me and said, what would help? You are in the HR world, you see it from the employee and the employer perspective, what would help? So what we did was a lot of negotiation over time, and I really appreciated that, with making sure that there was a full year ahead of time of training and preparation, education awareness, which the Civil Rights Division has been doing since this bill, since 1136 passed. In addition, I did put out the offer again to my HR network across the state pro bono that they would go in and do these trainings for small businesses, which are still available. So go ask your local Chamber of Commerce, and there are avenues, there are trainings, there is an online training now. So that was one of the issues. And then the other was, I want to make sure that this is the last resort, because as many of you know, I'm a big mediation fan, and I believe in alternative dispute resolution. I believe in making sure that the courtroom is the last place of resort. So we made sure that in negotiating on that bill that there were several steps before it even got to a court case, that you have to go through the CCRD, that you have an audience with them, then you have a potential for mediation. So the ones that could get to this level of being in the courtroom is so small and so severe and so minute that it would take a lot to even get there to the courtroom. So I think the other thing that was so questionable to me in this bill 69 also was, why are the people like my friend from Boulder who are over 70. Why are they protected and nobody else is? So I thought that that was odd as well. But I do want to say that the most effective way of handling discrimination in the workplace is not to do it at all. This is 2015. This isn't the 1960s. It's not the 1940s or 50s. This is 2015. And there should be no discrimination in the workplace. But if they still need the education as to what can appear to be discriminatory, then ask CCRD to do a training in your area. Ask my local or my members across the state of the HR organizations. They will come in pro bono and teach your businesses. So if you do not discriminate, this bill doesn't even apply to you. 1136 doesn't even apply to you if you do not discriminate. So for that, I ask for a no vote.
Is there further discussion? Senator Woods?
Thank you, Mr. Chair. And I do want to thank my colleagues for a very respectful and heartfelt and important discussion here today. I want to talk about a few things that have been mentioned. To the former speaker's last point, discrimination is very hard to prove, but it is very easy to allege. And to say, just don't discriminate, and then this bill doesn't apply to your business isn't true, because somebody can just claim a discrimination against you. And then you find yourselves in the situation that's covered by 1136. So it's not as simple as saying, just don't discriminate. Also, we've heard some talk about what's magic about the number 15, and I'm going to tell you the groups in this state that think 15 is magic. The Colorado Association of Commerce and Industry, the Colorado Competitive Council, the Denver Metro Chamber of Commerce, the Mountain States Employers Council, the Douglas County Business Alliance, the Highlands Ranch Chamber of Commerce, the Colorado Springs Business Alliance, Land Title Association of Colorado, the Colorado State Association of Health Underwriters, the Colorado Association for the Education of Young Children, the National Federation of Independent Businesses, the Colorado Civil Justice League, the Colorado Defense Lawyers Association, the National Association Insurance and Financial Advisors, Property and Casualty Insurers, Evergreen Chamber of Commerce, the Northern Colorado Legislative Alliance, the Colorado Ambulatory Surgical Center, the Colorado Association of Collection Agencies, Colorado Concern, Farmers Insurance, Colorado Auto Dealers, State Farm, the Aurora Chamber, the Colorado Technology Association, the Colorado Republican Business Coalition, the Colorado Contractors Association, and the Colorado Hospital Association all support Senate Bill 69 because that number 15 is magic. I also want to say that, to my good friend from Boulder's point, people over 70 were discriminated against prior to 1136. That's how the law was written in Colorado. These age discrimination claims only applied to people up to a certain age. And so 1136 did something right. They extended that beyond the age of 70 for age discrimination claims. And on the campaign trail, I found lots of elderly people still having to work. And so we thought that was important to keep in this part, in this repeal. That's the one part we're not taking out. Because the elderly who are at work, I don't care how old they are, they should be not discriminated against. So that is the reason that was in there. This bill doesn't eliminate protections at all. Protections are built into the federal law. And the federal classes that are protected are age 40 to 69, so it's a good thing we have this bill, color, creed and religion, disability, familial status, marital status, being married to a coworker, national origin or ancestry, race, retaliation, sex or pregnancy discrimination, sexual orientation, and then a category called other. So these are the categories that the federal law protects. Lastly, I want to say this is not about treating companies differently depending on their size. There are remedies for all employees. This bill is about not making victims of employers of less than 15 employees. Colleagues, I would just encourage a yes vote on this bill today. This is an important discussion, and I would like to see us continue the discussion. Let's send it over to the House. I would like to see their Business Committee hear it, hear the testimony. We had some very excellent testimony from a lawyer who works in this industry, who worked for the EEOC, and she came in and really gave us some great information. So I'm encouraging an aye vote today. And I thank you again for the great conversation and the discussion here today.
Senator Aguilar.
Thank you, Mr. Chair. Senator Woods, I sort of hoped I would have your notes, because what I thought I just heard you say is that you don't want to discriminate against people over 70, so that's why you left them in the bill. And what I'd like to hear is that we don't want to discriminate against anyone, and so we vote no for the bill.
Would ask members to refrain from referring to other members by name. Senator Ulibarri.
Thank you, Mr. Chair. I also wanted to acknowledge something that was just stated by the bill sponsor, claiming that there are federal protections based on sexual orientation. That has been a long, heated debate, and unfortunately, but probably not surprisingly, the federal government has not taken action. They don't generally do their job, the Congress hasn't, to extend protections on sexual orientation. Sexual orientation is not protected under the Federal Non-Discrimination Act. It's been a sore point for the gay, lesbian, bisexual, transgender community because there are real cases of discrimination based on sexual orientation. There is no federal protection. So Colorado's law was the only space where that protection existed. And so the repeal of 1136 with Senate Bill 69 eliminates that protection because there is no federal protection based on sexual orientation.
Is there further discussion on Senate Bill 69? Madam Minority Leader.
Thank you, Mr. Chair. You know, I debated saying anything on this. This is a very difficult debate to go through because I think at times there's a lot of cynical assumptions behind what people think might be ulterior motives to actually standing up against discrimination in the workplace. I want to go back to something a colleague of mine brought up. All of us now are belatedly celebrating Martin Luther King Day. We're 50 years after Selma. We're a little bit more than 50 years after we finally passed the Civil Rights Act of 1964. Title VII of 1964 guaranteed Americans. It was part of establishing, planting a flag and saying that we as Americans do not believe in discrimination. We believe that all people have the right to be judged by their merits, by their behavior. And while that promise was given to us by our founders, we all know that it has taken stages in the process of trying to create an ever more perfect union before we have been able to see and live and experience something resembling the American ideal against discrimination. When people attribute cynical motives to why we would want to extend the same discrimination, anti-discrimination protections for employees regardless of size, I guess I ask. This is a historical flyer that has been handed to you. When Martin Luther King Jr. did the March on Washington for Freedom and Jobs, he was marching in support of creating these rights. All we're doing when we first passed this bill is very, very, very belatedly bringing Colorado up to speed so that all workers finally have the same rights. So I guess my question is, when we heard the I Have a Dream speech, which we all know, which was the pinnacle speech that was delivered on the March for Freedom for Jobs on Washington, do we think he was trying to help insurance brokers make money? Do we think Martin Luther King was marching to try and enrich trial lawyers? No, I don't think so. What bothers me about current law and the arguments that are raised on this is Even with passage of 1136, it is separate and very unequal and a very much more barriered process for people to exercise their civil rights. In that bill, you will find that almost no other state has a cap of $10,000 for employers with 1 to 4 employees and a cap of $25,000 for employers with 5 to 14. Their actual losses, their actual harms may never actually reach those levels. So let me ask you this. That's just your civil rights. That's our civil rights. But if any other right of any of you in this room is violated, other than a civil right, you don't have a $10,000 cap. You don't have a $25,000 cap. If you are wronged in some other way, there is no other set of rights that is so heavily restricted, where we have added an exhaustion of administrative remedies, the number of barriers we have put in place to ordinary men and women to live and enforce their civil rights is frankly rather appalling. Because in other areas, your other rights that aren't your civil rights, you don't have to exhaust your administrative remedies first, and you don't have to basically live under a cap like this. So for those of us that aren't moved by thinking that the things we do here are for cynical motives and that the things we're doing here aren't really about enriching anyone, there's also a scenario where those of us here actually believe we have these rights. We believe that these are inalienable rights, that were endowed to us both by our creators and the founders of this country. Our founders planted the seeds of these rights. And I'm embarrassed that Colorado was so slow and so late in giving the same protections, the same civil rights, the same protections against discrimination to people. So what I wanted to share today is those of you, I don't know how many of you have daughters. You know, there's a lot of different classes we protect against religious discrimination in this bill. We protect against disability discrimination. All of these protections are getting repealed in this. But let me speak to you on a personal level for all of you who have wives, daughters, and sisters, because we all know the corner of what we know. If you talk to people outside of the legislature, and if they were to be honest with you about what some of their work experiences have been, you might be surprised at how common harassment is in the workplace. And I don't know, I didn't think it was funny, but to me, it wasn't funny. When I was 16, I worked at a family-owned Amoco gas station in Boulder. That station as a franchise had under 15 employees. And I was working while I was in high school to pay for my gas money and to pay for my car insurance. And shortly after I started working, nearly every day I showed up at work, I was fighting off the advances of my boss. And you have to ask yourself after a while, how long do you really want to show up for $4 an hour and have to fight off the advances of your boss, who is well more than twice my age, married? He would come in with his pregnant wife, leave, and because it's a small with a very short-staffed place, as soon as his pregnant wife would leave, the advances would start. And I went to work so that I could actually be responsible, pay for my insurance, pay for my gas. It was close to where I lived, and for me, it was an important part of my growing up experience where I wanted and I needed a job to help cover my own expenses. Why should anyone have to go to work and choose between their job and unwelcome advances? You have daughters, many of you out there too. I never filed a claim, but what I was able to do was I quit. I got tired of showing up to work every day and dealing with unwanted advances from a boss twice my age who is married and pretty actively trying to cheat on his pregnant wife. Talk to the people you know about their experience growing up, because the problem with it being under 15 wasn't just that it didn't have a legal remedy. The larger employers have HR departments. They have other channels. They have other routes of where you can go if you need to file a complaint on someone that works there. If I had a problem with my boss making advances at me, do you know who I could report it to? Him. Now, I was lucky. I didn't have children to support. I didn't have a family outside of myself to support. And I had a roof over my head. And if I quit my job, I would still have food and clothing and shelter. And I wouldn't have done without. But do you know how many people are not that lucky? I had the option to leave. I would contend first and foremost that I shouldn't have had to leave. But I did. I wasn't after a lawsuit. I never filed a claim. It is more common than you think. And if you have young women in your lives that are out there entering the workforce, you want to know that you can go after the bad actors to stop the behavior. Because nobody should have to face that when they're going to work. But more problematically is there are a lot more workers in Colorado who don't have that freedom. And for them, that is not a realistic choice, where they are not free to leave quite as easily without as many options as I have. So, to me, this is about the dignity of every single person. This is about the freedom to go to work hard, and be judged based on your merit. This is about the freedom to have a professional work environment where none of us, nobody, is facing discrimination on this. I'm proud of the work we did to belatedly get Colorado in the same place where all workers have the same civil rights, the same basic rights against workplace protection as you do over 15. It is an arbitrary line. It makes no sense. It makes no difference. And if you ask anybody out there, they have already assumed it is against the law. The majority of good actors out there have assumed that this is against the law for over 50 years. No one's going to be surprised that one day, oh, I thought I could discriminate based on age. And the important part about Colorado is because the federal law does not include sexual orientation in its category, it is exactly enforcement of the rights of Colorado's Anti-Discrimination Act that provides any protection for civil rights on discrimination for sexual orientation. When I support a bill that extends civil rights on the Anti-Discrimination Act, I'll tell you what I'm doing it for. When Martin Luther King himself said that his work is not finished, he knew that there was an exception in the bill that didn't afford, because the federal government has to have a size threshold because of the Commerce Clause. He knew the work would have to continue with the states. And that work and that fight is still continuing today on so many realms of our basic civil rights. But when he said, my work is not yet done here, there is more work for us to do, he was right. I think it is a noble cause. I think it is a right cause. I think it is appalling that it took us over 50 years to get there. But I am extremely proud that Colorado has now joined 44 other states that have decided that these rights are real and they deserve to have remedies. And for that reason, and so many more, I oppose Senate Bill 69.
Is there further discussion on Senate Bill 69? Seeing none, the question before us is the adoption of Senate Bill 69. All in favor say aye. Aye. Those opposed, no. No. The ayes have it, and Senate Bill 69 is adopted. Mr. Majors, please read the title to Senate Bill 86.
Senate Bill 86 by Senator Lambert, Representative Joshi, concerning criminal background checks performed pursuant to transfers of firearms.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 86 to March 23rd.
The motion is to lay over Senate Bill 86. All in favor say aye. Aye. Those opposed, no. The motion, the ayes have it, and the Senate Bill 86 will be laid over as requested by the Majority Leader. Mr. Majors, please read the title to Senate Bill 45.
Senate Bill 45 by Senator Lundberg concerning the creation of income tax credits for non-public education.
Senator Lundberg.
Thank you, Mr. Chair. I renew my motion for passage of Senate Bill 45 and would like to describe it briefly because we did have some discussion yesterday, but in deference to the time we had to cut that short. A couple of things I didn't say, one of which is I've actually been waiting over 20 years to have this debate and discussion here. It was Senator Cairns who had a bill similar to this back in the mid-90s that provided educational tax credits based largely on the law that's been in place in Arizona for many years. And I took those ideas and looked at what other states were doing and what the circumstance was, and have worked on what is now Senate Bill 45 for many years. So this is a long time in coming, a very important discussion that we need to face, and that is, what is the policy for the state of Colorado toward those educational formats that are not within the realm of what we call the public schools? We have homeschools, we have many private schools. Private schools have been around really longer than public schools have, and so is homeschooling for that matter. But the policy we have today simply encourages and fully funds public school, and we ignore a great resource we have here in the state of Colorado, and that is the dedicated commitment of parents and teachers and others who are seeking to find the best solutions for students on the private side. This is an incredible asset and resource for our state. And if you look at the results that come from those educational formats, they are remarkable. So why doesn't public policy encourage private school and homeschool? And that's what Senate Bill 45 is designed to do. And it's developed in such a way that it actually provides an economic benefit for the general fund, so that the dollars that are available for education are actually much greater on a per pupil basis. Now, I say much greater, it doesn't overwhelm the public system. As a matter of fact, if you look at the fiscal note, you'll discover that the best estimates on who will take advantage of this is actually a very small percentage, but it's enough to provide some relief to the financial strains we have on our public school districts from the growth that occurs. So this is not going to be a shocking and dramatic change, but I believe it's going to be a significant change of focus. And it is for those reasons and so many others that I renew my motion for the support of Senate Bill 45, and I thank you for your time, Mr. Chair.
Is there further discussion on Senate Bill 45? Senator Kerr.
Thank you, Mr. Chair. So, bringing up Senate Bill 45 again today, a little bit of Groundhog's Day from yesterday. We did hearing about the kind of the three types of schooling we have here in Colorado. Public schools, where we have a wide variety of choice involved in the public schools, whether it's the traditional neighborhood school. We have charter schools, both in neighborhoods and charter schools that are not always directly in the neighborhood that they're mostly serving. We have option schools. We have magnet schools. Quite a variety, and as choice is brought up, we do have quite a bit of choice in the public school sector that we're talking about. And with that choice, the vast majority of parents in my district that I'll talk about choose to send their kids to the public school and in their own neighborhood. But certainly I have neighbors and know people in my district that send their kids to charter schools and to option and magnet schools as well. In Jeffco, we have a good amount of choice there. The other tier, of course, we have homeschooling as well and private schools. And again, I know people in my neighborhood, I know my constituents. I have private schools in my area, and also I know neighbors who have either have or are homeschooling their kids. Generally seems to work well. And again, the vast majority do choose the public schools and the choices they have in the public schools. It was interesting yesterday when I heard mentioned at this podium that homeschools and private schools are merely tolerated in the state of Colorado, and I know that when we're perhaps there are people that feel that way, and I won't discount anyone else's feelings. I know for myself, I know families who are in situations where homeschooling works best for them. And I applaud their decision. As I have mentioned every year here at the legislature, that I was homeschooled for about 3 years when I was younger as well. So in those situations where it makes sense for a family for a particular time or for the entire education of their children, that's great. Some people choose to go to a private school, and again, that is their choice, and they make that choice based on what's best for their kids' education and for their family situation. I applaud that decision as well. I want to make very clear here that, in my opinion, private schooling and homeschooling is not something that's tolerated, but it's something that's an integral part of the education system here in Colorado. So, in addition to that, we heard that we need to make a more efficient use of taxpayer dollars, and that by doing this, by this backdoor voucher system being proposed in Senate Bill 45, that this is a more efficient use of taxpayer dollars. And as was requested of us, is that we look at the fiscal note. So I'm looking at the fiscal note, and I look at state revenue for this upcoming year, 2015-2016. I'm looking at state revenue. State revenue is predicted to go down by over $12 million. So for those of you that don't watch Channel 165 or aren't here at the Capitol every day, we call that a pretty big fiscal note. $12 million in state revenue that will be gone, will not come in next year because people who choose to take this tax credit will be taking that tax credit and cutting out $12 million of state revenue. And as we all know, a big chunk of that goes to our public school system. Also, as I go down the fiscal note, and there's something that's been appearing on our fiscal notes this year, and that's called the Tabor set-aside down below. which actually matches the decrease in state revenue up above, 12.1 million. So the Tabor set aside is money that would otherwise be refunded to taxpayers next year. There will now be $12 million less going back to taxpayers because of Senate Bill 45. And again, Senate Bill 45 is for a small number of people, of families, taking a tax credit. The Tabor set aside, $12.1 million, is $12.1 million that will be going to all taxpayers. The working poor, the very wealthy, and the middle class. Whereas Senate Bill 45, the tax credit for Senate Bill 45 is just going to a small select group. So as we're talking the fiscal impacts, the fiscal note, that is what I see when I look at our fiscal note. So when it's mentioned that this bill will be good for the finances of Colorado and will be good for making education more efficient here in Colorado, I urge all members to take a look at the fiscal year 2015-16 column of the fiscal note. But if we do move forward with Senate Bill 45, and we are going to do this, I think it's important that we talk about all kids, talk about the entire system, making sure that students are being educated, that schools are being held accountable. And over the last 10 years or so here at the Capitol, we've certainly worked a lot on school accountability, because I've heard from many of my constituents how they want to make sure that their taxpayer dollars are going into a school system that is effective and that there is some sort of proof that the taxpayer dollars, again, I go back to the $12.1 million fiscal note here, that taxpayer dollars that are being used to educate students, that those schools, the teachers in those schools themselves are being held accountable.
There is an amendment on the desk. Mr. Majors, would you please read L012?
Amendment L012, Senate Bill 45 by Senator Kerr, amend printed bill page 7 after line 5, insert
Senator Kerr.
Thank you, Mr. Chair. Mr. Chair, L012 is an amendment that makes sure that the schools that are...
Move the amendment, please.
Thank you, Mr. Chair. I move L012.
Thank you, Senator Kerr. To the amendment.
Thank you, Mr. Chair. L012 is an amendment that makes sure that the schools that accept these students whose families are receiving this tax credit, and as we've talked about this being a backdoor voucher system, there's not an actual voucher, but in effect that these schools and the families are enjoying this tax credit, that the schools that accept these students will be held accountable by having their students be part of the accountability system that we have set up for our public schools, for schools that use public dollars. So with that, I would ask for the adoption of L012 to make sure that taxpayer dollars being used to educate students, that those schools are being held to the same accountability measures that all schools are here in Colorado.
Senator Lundberg.
Thank you, Mr. Chair. I urge the members to reject this amendment. This is an amendment that would say private schools now have to take the PARCC testing, which is almost universally hated, and subject them to the same heavy-handed mandates that I find complaints from just about everybody across the political spectrum. And also the sponsor of this amendment stated that this is not a voucher, because some argument can be made towards additional rules. I think it's an unnecessary and actually counterproductive, but Senate Bill 45 is intentionally a tax credit, and that is to eliminate the necessity or the requirement or even the argument for all of these strings that the government systems want to put on the private side. Listen, private schools prosper in Colorado because they don't have this ridiculous stack of mandates placed upon them, and that's what this amendment will do, is it'll start marching us down that road towards, unfortunately, mediocrity and inefficiency for our private schools. This is not a good amendment. Please vote no.
Senator Kerr.
Thank you, Mr. Chair. And that's exactly what this body, this legislature has done around implementing testing, implementing different forms of accountability, is making sure that taxpayer dollars are accountable to the taxpayers. That is our charge here. That is what we are supposed to do. It has been said here at this podium that private schools prosper because of the strings that are not attached to them. Then why is it that this body and this legislature has attached so many strings to so many bills to all of our public schools in Colorado, to hold our public schools accountable? And I've certainly heard from my constituents that that is what they want. They want the accountability. They want to make sure that when they pay $1 in taxes and it goes to a school, that that school is going to use that dollar wisely. Now, the families who are going to benefit from Senate Bill 45, the families that are set to benefit from Senate Bill 45, certainly they're going to see a financial benefit through those tax credit dollars. And at the same time, be spending probably, I believe that's the design of the bill, spending those dollars at the school where their children now go. Why is it not okay for taxpayers to know where their dollars are going and to know how those dollars are being spent, and to make sure that the schools where those dollars are being spent are held to the same high standards that we hold our neighborhood schools to, that we hold all of our schools, all of our teachers, and all of our students in public school to? Why is it not okay, Mr. Chair? Why is it not okay for those students and those teachers and those schools to be held to the same high standards?
Senator Lundberg.
Thank you, Mr. Chair. I'll try to be brief here, but a couple of points that have been made by the sponsor of this amendment, I believe, do deserve a question or an answer to his questions, and one of which is, as a tax credit, those dollars never went to the government in the first place, and so that particular taxpayer chose to take their dollars and put them to work where they know it will do the most good. That's what a tax credit is all about when it's an educational tax credit. It's not taking dollars from the state treasury. It's enabling the taxpayer to make that choice and that decision on their own. And if they want to, and remember, the way this works with Senate Bill 45, either the family can provide the tuition dollars for which they would get a tax credit directly, or some other benefactor could step up and provide a scholarship for an individual student to pay the amount of tuition that 45 would allow, which is only half of what the average funding for a public school student would be in place. But that particular individual, that taxpayer, would take those dollars and put them where they know they will do the best job. That's direct accountability. We don't need to be putting these bureaucratic, centralized control mandates on a private school, because the accountability is direct to those providing those dollars for the tuition of that student to that private school. This amendment is not only unnecessary, it would be a very bad step in the wrong direction. Urge a no vote on Amendment 12.
Senator Heath.
Thank you, Mr. Chair. And if this is unnecessary, then certainly all of the doors that I knocked on who asked me to make certain that we could justify all the dollars that went into public schools, then it's unnecessary for them too. To say this is not taxpayers' money is just a ridiculous argument in my opinion. This is money that we could say we'll give the money to them and then we can give it back. This is taxpayers' money when you get a tax credit. When I ran, quote, the Dirty Dozen back there, we had a long time discussion about tax credits and whether or not they were basically taxes. They are. We're giving a credit for a tax because that's the decision we made. The fact that it didn't get paid in and get returned really is just an argument just about how we make a tax credit work. The fact of the matter is this is taxpayers' money, and if I heard them right, they have the absolute right to know where that money and how it's being spent, whether it's in a public school or a private school. And as taxpayers' money, I think that the average voter out there is going to want to know where that money is being spent, wherever it goes, because it's their money. So not only is this necessary, it is paramount to basically understanding how we are educating our kids, no matter where they are. I would ask for the support of this amendment.
Senator Lundberg.
Thank you, Mr. Chair. You don't have to take my word for it as to whether these dollars are government dollars or private dollars. That's one of the reasons I based Senate Bill 45 on a long-established practice and law in the state of Arizona. They have been required to prove this up in the courts on multiple occasions. And each time it comes down the same way. These dollars are not government dollars, and they do not require the accountability that happens when it comes through the government. No, these are taxpayers who are given the option to take some of their dollars and employ them directly where they know they will do the most good. It's been argued many, many, many times, and the simple answer is the person who does not pay the tax bill but is allowed to use those dollars in a more efficacious fashion, it's up to them, not us, for the accountability of those dollars. And, you know, I'd even add this one element, too, and that is nobody has come down to the mic and to say the private schools in the state of Colorado are doing a bad job. So, really, what are we trying to measure that we are not already convinced of the result of? This amendment will simply erode the effectiveness of the program established in Senate Bill 45.
Is there further discussion on Amendment L012? Seeing none, the question before us is the adoption of Amendment L012. All in favor say aye. Aye. Those opposed, no. No. The noes have it, and Amendment L012 is lost. There is another amendment on the desk. Mr. Majors, would you please read the title to Amendment L013?
Amendment L013 to Senate Bill 45 by Senator Kerr, amend printed bill page 7 after line 5, insert paren 8, and paren any private school that issues a credit.
Senator Kerr.
Thank you, Mr. Chair. I move L013 and ask for its adoption.
Is there discussion on Amendment L013? Senator Kerr.
Thank you, Mr. Chair. So the previous amendment, we're looking to hold the schools accountable by having all of the students in that school take the same exams that all kids in public schools are taking. And I thought it was a fair argument that, hey, you know, these are private schools. They're all private schools are doing such a great job. This is the point behind Senate Bill 45, since all private schools are doing so well. But Senate Bill 45 is a departure from the way that we've set up what I think we've heard from both sides of this bill is a pretty successful overall schooling system here in Colorado. It's trying something new. And one thing I think that we should definitely do, there have been lots of different types of, generally they're called education reform measures, trying something new. If we're going to try something new, I think we need to collect data on that. We need to know how well a bill that we pass here in the Senate, at the legislature, how well that bill is doing at what it's supposed to do. And I believe Senate Bill 45 is designed to try to improve educational outcomes, to improve the educational achievement of students. And I applaud the sponsor on that goal to try to improve education throughout the state of Colorado. But we should not be throwing away money, $12.1 million in revenue that otherwise would be going to our public education system. We should not be just letting that money go without having some sort of accountability and data on that fiscal note. If we're going to transfer $12.1 million in tax rebates to the middle class and the working poor and the very rich, who will all share in the tax rebates of $12.1 million, this fiscal note says, and we're going to shift that over to just a select few families who take advantage of this tax credit, we should make sure that we collect the data that says that the educational outcomes of these students is actually improving. And that is what L013 does. It says the students who were in public school the year before, as this bill stipulates, they were in public school the year before, and now they're coming to the private school, that they will take the same standardized assessment that all the students that they left behind that are still in the public schools, that those students are taking, and they will take that assessment as well. And if Senate Bill 45 is working the way it's designed, we should see, and these students now going to these wonderful private schools, as we've heard here, no argument from anyone that the private schools in Colorado are doing a bang-up job. We should see the data immediately that the educational outcomes of these students is improving. And that is what L013 does. It holds Senate Bill 45 accountable for that $12.1 million. If we're going to take $12 million out of our public education system and put it into the private schools, let's make sure that that's $12 million that is well spent. And I can tell you that with this amendment in the bill and this bill passing and getting signed into law, we get the data that shows that Senate Bill 45 is working as intended. I will be the biggest proponent. I'm all about improving educational outcomes in Colorado, and with this amendment, we'll be able to track that, and I will become the biggest supporter of Senate Bill 45 in the future.
Senator Neville.
Thank you, Mr. Chairman. Well, I'm glad to see the senator from Lakewood here admitting that private schools in the state of Colorado are doing a bang-up job. And actually, let's go ahead and make sure that we know that those homeschoolers out there are doing a bang-up job. So I'm a little confused why the senator from Lakewood is wanting to then increase the bureaucracy of those private schoolers and also those homeschoolers, well, actually private schoolers only in this amendment, this latest amendment, one of many, to actually increase the bureaucracy and increase. And I'm confused if this is requiring further assessments, and we're already hearing how popular those assessments are right now. So I'm a little confused if the senator is encouraging the further use of more assessments, and also does that include the park assessments and the Common Core?
Senator Lundberg.
Thank you, Mr. Chair. Members, we've argued the merits of this amendment on previous amendments. Vote no.
Is there further discussion on Amendment L013? Seeing none, the question before us is the adoption of Amendment L013. All in favor say aye. Aye. Those opposed, no. No. The noes have it, and Amendment L013 is lost. There is another amendment on the desk. Mr. Majors, would you please read Amendment L026?
Amendment L026, Senate Bill 45.
Senator Ulibarri.
Thank you, Mr. Chair. I move L026.
To the amendment.
It changes a phrase from shall not to may, making it permissive.
Is there further discussion on Amendment L026? Senator Lundberg.
Thank you, Mr. Chair. Having seen this amendment for about 10 seconds, I will take the time to actually see what it says. It says, amend printed bill, page 5, line 26, strike shall not, and, okay, any credit remaining after said period shall not be refunded or credited to the taxpayer, and simply say may not be, or may be refunded. My net result or response on anything that I haven't had time to digest is to simply say no.
Senator Ulibarri.
Thank you, Mr. Chair. I'll provide a little bit more context for this one. So Senate Bill 45, as written, creates a non-refundable tax credit, which means that those with tax liability, meaning those in the upper income brackets, those with immense tax liability, are the only ones who can currently benefit from said tax credit. By making it a refundable tax credit, not one that is non-refundable as it's currently built, means that working class families, middle class families who want to use this tax credit could. If they have no tax liability because they are working at the margins, they are working hard and maybe have other tax offsets, then they should be able to benefit from this credit, unless this credit is only designed to benefit the wealthy few.
Senator Lundberg.
Thank you, Mr. Chair. And in some ways, I'm attracted to opening this up in a more broad fashion, except for when you make it a refundable tax credit, it's no longer just a tax credit. It actually does draw down dollars from the Treasury and of the state, and that's a dilemma. So what we did instead is we made a provision so that if you wish to provide a scholarship for a student who cannot afford it otherwise, you can do that as a taxpayer. Therefore, Senate Bill 45 has the ability to provide funding for students on the private side, regardless of their family's personal wealth. If there is some private benefactor who wants to take advantage of the tax credit, and provide it for other students. And we've seen this done quite a bit, even without tax credits. I'm sure that this will be an appropriate incentive. No, I don't want to make this an elite thing. As a matter of fact, that's what 45 is all about, is to provide the ability for families who cannot afford tuition in their current circumstances to be able to afford the tuition costs on the private side. Or if it's a homeschool situation, to provide some of that financial relief necessary to get those funds and curriculums. It's just that we're trying to craft 45 so that it works very well and doesn't have the strings that so inevitably come when the government does, in fact, start taking dollars out of the Treasury for a private concern.
Senator Ulibarri.
Thank you, Mr. Chair. I want to respond to a couple of comments that were just made about L026. L026 is designed for those individuals who are middle class, working class, who want to be self-sufficient. But what I heard is that, the sponsor opposes this amendment, doesn't want to open it up to those middle class and working class families because they should instead rely on a private benefactor. I don't know many middle class families or working class folks who have a private benefactor just waiting in the wings to fully sponsor their education. If we are talking about individual responsibility and self-sufficiency of working people, why should they not be able to receive this credit on their own without the help of a private benefactor?
Senator Lundberg.
Thank you, Mr. Chair. I actually do not find it appropriate for my intentions to be characterized, especially when they're mischaracterized. My concern with this amendment is that it turns a tax credit into something other than a tax credit. And Senate Bill 45 is very carefully crafted to ensure that we are talking about dollars that are not coming from the state's treasury. As I say, there's some interesting, intriguing elements within this, but it really defeats the crafting of this bill that has been literally decades in the works. So, yeah, I'm a no vote. I trust others will be as well.
Senator Merrifield.
Thank you, Mr. Chair. Well, I rise in support of this amendment, and I just want to make sure you're aware of a couple of facts. One, that only 20% of private school students attend non-sectarian schools, and the other 80% are in religiously affiliated private schools, of which half are Catholic. And two, the cost of private schools is very high, but it varies widely. On average, the tuition is about $11,000, not counting discounts or scholarship, ranging from $7,000 for Catholic schools, $9,000 for other religious schools, and up to $22,000 for non-sectarian private schools. Tuition tops out at about $40,000 for the most expensive prep schools. So given this high cost, kids from richer families are far more likely to go to private schools than kids from poorer families. 6%, only 6% of kids in households with incomes under $50,000 attend private schools, compared with 26% of kids in households with incomes of $200,000 or more. This amendment would give a little bit more opportunity for parents who are in the lower income brackets, to give an opportunity for them to send their children to private schools. So I would support this amendment. It's only logical.
Is there Senator Neville?
Thank you, Mr. Chair. I oppose the amendment. I hope Senator Merrifield would join us and actually possibly, I apologize. I hope the distinguished senator from Colorado Springs would join us in actually increasing, possibly at some point, the tax credits, so we can actually provide more help for those families that lower income that would actually benefit from sending their kids to schools of choice.
Senator Ulibarri.
Thank you, Mr. Chair. Specifically to this amendment, L026, that low-income families or middle-class families cannot actually benefit from this credit because they don't have the tax liability to wipe it out. So if this is designed to actually reduce the cost of private school for low-income or middle-class families and they have no tax liability, they cannot use said credit. Therefore, there is a specific prohibition, as Senate Bill 45 is currently drafted. There is a prohibition against middle-class families and low-income families who have no tax liability from receiving this benefit. So this is not for them, it's for the wealthy few.
Senator Lundberg.
Thank you, Mr. Chair. Please vote no on this diversion from the real bill.
Is there further discussion on Amendment L026? Senator Marble.
Thank you, Mr. Chair. I'm just recollecting back on, I went to a private Catholic school, and we did have scholarships for those who were special needs people who really didn't have the tax credits. And we had quite a few of them, and they were people who were allowed to donate money to the school specifically for those children who were very much the needs-based. And so it was already taken care of. And in a very good way, and it really got the community involved. But then those who did have a tax, and they were paying and stuff, but they weren't rich, they could use some of their money for this. And so I can see where most of these schools that I understand, they do have scholarship available for the needy families, and the ones, they're all taken care of, because the schools that I went to and the people that I know who went to private schools, they did have scholarship funds for those needs-based children. So I would say that this isn't really a necessary amendment.
Further discussion on Amendment L026? Seeing none, the question before us is the adoption of Amendment L026. All in favor say aye. Aye. Those opposed, no. No. The noes have it, and Amendment L026 is lost. Majority Leader Scheffel.
Thank you, Mr. Chairman. Move that Senate Bill 45 lay over to March 23rd. Ask for an aye vote.
The motion before us is to lay over Senate Bill 45. All in favor say aye. Those opposed, no. Senate Bill 45 will lay over as requested by the Majority Leader. Mr. Majors, please read the title to House Bill 1202.
House Bill 1202 by Representative Singer and Senator Woods concerning the ability of a licensed authority to reissue expired alcohol beverage licenses.
Senator Woods.
Thank you, Mr. Chair. I move House Bill 1202, and there are no committee reports.
To the bill, Senator Woods.
Thank you, Mr. Chair. This is a bill that will allow anyone who holds a liquor license in their business, if their 90 days expires, they will get an extra 90 days to renew. They will have to pay late fees and penalties, but it flows from the floods we had in 2013 where some establishments were washed away and their liquor license went with it, and then they found themselves out of license and needing to renew and go back through the needs and desires and the difficult, expensive process. So it has flown through the House and our committees all unanimously, and I'd ask for an aye vote.
Is there further discussion on House Bill 1202? Seeing none, the question before us is the adoption of House Bill 1202. All in favor say aye. Aye. Those opposed, no. The ayes have it, and House Bill 1202 is adopted. Majority Leader Scheffel.
91.
Oh, Mr. Majors, please read the title to Senate Bill 91.
Senate Bill 91 by Senator Scott concerning reduction in the statutory limitation period applicable to legal actions for construction defects on improvements to real property.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Move the committee lay over Senate Bill 91 to March 23rd.
The motion before us is to lay over Senate Bill 91 to March 23rd. All in favor say aye. Aye. Those opposed, no. Senate Bill 91 will be laid over to March 23rd. Mr. Majors, would you please read the title to House Bill 1244?
House Bill 1244 by Representative Singer and Nordberg and Senators John and Lumber concerning the ability of members of a club license under the Colorado Liquor Code to remove from the club a resealed container of partially consumed vinous liquor purchased at the club.
Senator John.
Thank you, Mr. Chair. I move House Bill 1244. There is no committee report.
To the bill.
Well, this bill was actually on the consent calendar yesterday, but since it was the only one there, they decided to move it into the full calendar, and then they didn't get to it anyway, so we'll do it today. Senate Bill 1244 was completely fixed for a bill that we carried a few years ago, the initial cork and carry bill. As all other legislation that we pass, we actually had made an error in that, and the nonprofit club licensees were not included. They were supposed to be included, like the VFWs, Eagles, Elks, so we are simply adding them in. There was no opposition in the House, no opposition in committee, and we're hoping no opposition on this floor either. Mr. Chair.
Is there further discussion on House Bill 1244? Seeing none, the question before us is the adoption of House Bill 1244. All in favor say aye. Aye. Those opposed, no. The ayes have it, and House Bill 1244 is adopted. Mr. Majors, please read the title to House Bill 1072.
House Bill 1072 by Representative Fields and Senator Newell concerning harassment through an interactive electronic medium.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Move that House Bill 1072 lay over to March 23rd.
The motion before us is to lay over House Bill 1072 to March 23rd. All in favor say aye. Aye. Those opposed, no. House Bill 1072 will lay over to March 23rd. Mr. Majors, would you please read the title to House Bill 1095?
House Bill 1095 by Representative Carver and Senator Lundberg concerning an extension of the exemption under the Colorado Common Interest Ownership Act for certain small common interest communities to include communities created before July 1st, 1992, whose declarations limit their annual common expense liability to no more than $300.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Move the committee lay over House Bill 1095 to March 23rd.
The motion before us is to lay over House Bill 1095 to March 23rd. All in favor say aye. Aye. Those opposed, no. The ayes have it, and House Bill 1095 will lay over to March 23rd. Mr. Majors, would you please read the title to House Bill 1046?
House Bill 1046 by Representative Moreno, Senator Scott concerning authorization for the Executive Director of the Department of Transportation to waive department project cost estimate based statutory contract amount limits when awarding a highway project contract.
Majority Leader Scheffel.
Thank you, Mr. Chairman. Move the committee lay over House Bill 1046 to March 23rd.
The motion before us is to lay over House Bill 1046 to March 23rd. All in favor say aye. Those opposed, no. The ayes have it, and House Bill 1046 will lay over to March 23rd. Mr. Majority Leader.
Thank you, Mr. Chairman. Move the committee rise and report.
The motion before us is to rise and report. Those in favor say aye. Those opposed, no. The ayes have it, and the committee will rise and report.
Thanks. The Senate will come back to order. Senator Holbert.
Thank you, Mr. President. Your committee has met, had a number of bills under consideration. Mr. Majors, would you please read the report?
March 20th, 2015, Mr. President, your committee, the whole basis reports that in consideration of the following tax bills, being second reading thereof, makes following recommendations thereon. Senate Bill 69 is amended, passed on second reading in order to gross place the counter for third reading and final passage. House Bill 1202, House Bill 1244, passed on second reading in order to revise place on counter for third reading and final passage. Senate Bill 135, Senate Bill 86, Senate Bill 45, Senate Bill 91, House Bill 1072, House Bill 1095, House Bill 1046, laid over until March 23, 2015, retaining their place on the calendar.
Senator Holbert.
Thank you, Mr. President. I move adoption of the report.
You have heard the motion. Is there discussion? Are there any no votes? With 35 ayes, 0 no, 0 absent, 1 excused, none excused. Committee of the whole report is adopted. Senate Bill 69 is amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1202, House Bill 1244 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Senate Bills 135, 86, 45, 91, 1072, 1094, 1095, 1046 laid over until March 23 and retaining their place on the calendar. Majority Leader Scheffel.
Thank you, Mr. President. Move that the Senate lay over consideration of House amendments to Senate resolutions to March 23rd.
You've heard the motion. All those in favor say aye. Opposed, no. Consideration of House amendments to Senate resolutions for Senate Joint Resolution 4 will lay over until March 23rd. Consideration of Governor's Appointments Consent Calendar. Mr. Majors, would you please read the title of all the appointments on the Governor's Appointment Consent Calendar?
Member of the Board of Assessment and Appeals for a term expiring July 1st, 2015, Amy J. Williams of Hayden, Colorado, engaged in agriculture, reappointed. Members of the Securities Board for terms expiring July 1st, 2017, Eric Kenley Lidstone of Centennial, Colorado, member of the Public at Large, appointed. Mashenka Lundberg of Golden, Colorado, who is licensed by the State Supreme Court to practice law in the state of Colorado and who is conversant in securities law, reappointed.
Majority Leader Scheffel.
Thank you, Mr. President. Move that the Senate confirm all of the governor's appointments listed on consideration of governor's appointments consent calendar, which includes a member of the Board of Assessment Appeals and members of the Securities Board.
You have heard the motion. Is there any discussion on any of the appointments on the consideration of governor's appointments consent calendar? Are there any no votes on any of the appointments? With 35 ayes, 0 no, 0 absent, 0 excused, Amy J. Williams is confirmed on the Board of Assessment Appeals. With 35 ayes, 0 no, 0 absent, 0 excused, Eric Kenley Lidstone and Mashenka Lundberg are confirmed on the Securities Board. Conference committees to report. Mr. Max, Mr. Max. Where's Randy? Where's Randy? Okay. It's got to be Friday somewhere.
First report of the First Conference Committee on Senate Bill 161. This report amends the re-revised bill to the President, the Senate, and the Speaker of the House of Representatives. Your First Conference Committee appointed on Senate Bill 161 concerning a supplemental appropriation of the Department of Revenue has met and reports that it has agreed upon the following: that the Senate accede to the House amendments made to the bill as amendments appear in the re-revised bill with the following changes. Respectfully submitted, Senators Kent Lambert, Chairman, Grantham and Stedman, Representatives Hamner, Chairman, Young and Rankin.
All right. Delivery to the Governor.
To the Governor for signature on Thursday, March 19, 2015 at 1:35 p.m., Senate Bill 191.
Signing of bills.
March 20th, 2015, the President has signed House Bills 1035, 1106, 1144, and 1188.
Introduction of bills.
Senate Bill 224 by Senator Sonnenberg concerning a permitting exemption for systems that remove groundwater from soils that are adjacent to foundations.
Senate Bill 224 is assigned to Agriculture, Natural Resources, and Energy. Announcements. Senator Lambert.
Joint Budget Committee will meet at 1:30 today.
Senator Todd for a better announcement.
Thank you, Mr. President, and want to encourage all of you to mark your calendars. You got a schedule. Monday is Aerospace Day at the Capitol. There will be many guests here that are representing, be it Lockheed Martin or CU, Metro State, many of our universities. Hopefully you're following all the good news of things that Colorado is in the news for NASA, and so encourage you to join on the first floor some of the different displays that will be present, and welcome all of our guests on Monday for Aerospace Day. Thank you. And have a wonderful weekend. Go Jayhawks.
Further announcements. Mr. Majority Leader.
Thank you, Mr. President. Colleagues, something to keep in mind as you head into the weekend, and more importantly, when you come in on Monday, It's true, it's your daily clicker announcement. Just a reminder, when you come in on Monday morning, you will need to use your new clicker. New clicker. When you enter the circle, the old clicker will no longer work. You will want to turn that in to the sergeants. If you noticed confusion coming into the circle this morning, that's because members of the House engaged in premature use of new clickers. This is what we deal with. So, that concludes the clicker announcement. Notwithstanding the fact that it is Friday, we are going to recess and leave the desk open. We're going to try to read some more bills over, but you do not have to attend that. Enjoy your weekend. Mr. President, I move that the Senate recess to 2 p.m. this afternoon.
You've heard the motion. All those in favor say aye. Opposed, no. The Senate will be recessed until 2 p.m.